your discretion. The court will now take the third case on today's docket, Woodbury versus the state of Florida. Counsel?
May it please the court, Mara Herbert on behalf of Appellate Michael Lawrence Woodbury. I'd like to reserve 5 minutes for rebuttal and focus this argument mostly on point 1, and if time permits, briefly address point 2. Within the context of competency, procedural protections are implemented to minimize the risk that a defendant will not be provided his constitutional right to a fair trial. It is essential for a trial court to observe these procedural requirements, not only to safeguard defendants' due process right to a fair trial, but to provide this court with an adequate record on appeal, which is of special importance in death penalty cases where there's a strong interest in ensuring the reliability of death judgments. One such procedural safeguard is found in Rule 3.111D, which sets forth the requirements the court must follow prior to granting self-representation. Subsection 3 adopts the competency limitation to self-representation held to be constitutionally permissible by the U.S. Supreme Court in Indiana versus Edwards. So therefore, for a trial court to properly follow this rule, it must determine whether or not this limitation applies. Specifically, the court must determine whether or not the defendant's illness, and if the court does find that, they have to determine whether or not he does not suffer from severe mental illness to the point where the defendant is not competent to conduct trial proceedings by himself. It follows that to ensure the uniformity in the application of this rule, the court has to make this determination on the record as to whether the limitation applies prior to granting self-representation. That way, the court considers this limitation in all cases where there's a defendant with mental illness, and to do otherwise would not guarantee that all courts would consider it and would not establish an adequate record for appellate review. And this is also consistent with how this court has interpreted the rule and how lower courts have subsequently applied it. And I would just cite to the case of Hernandez, Alberto versus State, where this court said you must make that determination before granting self-representation, and to a case that an opinion written by former Justice Lagoa when she was in the 3rd District, Moore versus State, where it says that a part of the Feretta inquiry is to determine whether or not the defendant has a severe mental illness.
Counsel, I'm sorry to interrupt you. It's hard to see what more the trial court here could have done than repeatedly, to the point that the defendant here was obviously, felt like it rose to the level of harassment, basically. And I'm not faulting the trial court for trying to be so conscientious about it, but I mean, if you just look through this, you're struck by the consistency and how the frequency of looking into these issues. So I don't understand what you're faulting the trial court for here.
Well, I think the court looked at it within the mental capacity to waive the right, but the court didn't look at it within the capacity of severe mental illness and the effect it might have had on his ability to represent himself. I mean, he knows that this defendant has a major mental illness, a bipolar disorder, which is probably one of the most serious mental illnesses you could have. Is also neurobiological in nature, which could have cognitive deficits that are lying under the surface that the court itself is not trained to be able to assess. So in order to properly grant self-representation, I think in this case, the trial court had to first determine whether or not it was severe mental illness, which I think based off of this record, it would qualify as severe mental illness, and then determine if he was able to, sufficiently represent himself given the nature and extent of his mental illness.
How would the trial judge do that? Request an evaluation to see if he is competent to do these things?
Yes, I would say that, Justice Lavarga. I think an evaluation would be necessary in this case, given the nature of his mental illness. The U.S. Supreme Court did say in Indiana versus Edwards that the standard to represent yourself is higher than that of competency to proceed to trial. And in those cases, we require evaluations before making a determination so that the courts can apply as an decision.
He was, your client was not complaining, but relating to the court that he's been apparently suffering with some type of mental illness for a long time. And he was taking medication, Tegretol, I think is something he was taking. Yes, what is educate me, what is the effect of Tegretol on people?
There was actually some information in the record that the defendant did suffer from some side effects, which could affect his attention span, which could lead to nervousness. So it could have effects on him. I mean, a psychotropic medication can have effects on cognition. And I don't think from just asking him if he's taking it and if he feels okay, he wouldn't know if he wasn't feeling okay. I mean, that's the nature of mental illness. And I think that's also something that the court heard him say, is like, I don't believe I have it, or I think, that branch of science is a bunch of quacks. I mean, that could also be a symptom of mental illness if you understand it within the context of bipolar disorder. And that's why I put in my brief, a lot of information on anosognosia.
So what you're saying,
if you look at his actions within the context of
what you're saying is then that once the court became aware of these conditions, that in order to comply with 311, you should have ordered a mental evaluation to see whether this person is not capable, but I guess mentally, capable to represent himself. Not from a skill standpoint, but mentally.
From his mental state, but his actual, because that's why I included information about Dr. Suss's report, really just to show as an illustration of what a mental health professional might have been able to determine about his mental state that a trial court without training in mental illness wasn't able to see. I mean, we have an actual doctor saying that he believes that him to be in the active manic state of bipolar disorder during the time he's supposed to be preparing for his penalty phase trial. So in that case, it just shows you the limitations of just basing a competency determination on the observations of the trial court. And I think that it's instructive to see the way we handle competency to proceed to trial, which is a lesser standard, we have evaluations. And I think in this particular circumstance, when you have a mental illness that has been a decades-long struggle, that has a history of hallucinations, delusions, of abnormal thought processes, that the court has to take that step and order that evaluation in order to make a wise decision as to whether or not he's actually capable of representing himself.
And counsel, the standard of review here, though, is abuse of discretion, right? So it's not,
yes,
we aren't here asking ourselves, what would we have done, et cetera. It's could any reasonable trial court, based on what was in the record about how the defendant was conducting himself and, obviously with a lot of sensitivity by the trial court to this person's performance. The question is whether, given what we've seen on the record from the behavior, whether no reasonable person would have failed to order a competency evaluation or a mental health evaluation at that point. Is that right?
Yes. And I also think it's important to look at all the other cases that are involving this issue. I mean, pretty much every case, I couldn't find one where you have a defendant with a serious mental illness who hasn't been evaluated either for competency to proceed to trial or for competency for self-representation. This is one of those outlier cases where you have a defendant who's allowed to represent himself in a capital case, and at no point has anybody ever assessed his competency. And I would also say that, within the context, I think it's instructive to look at the competency to proceed to trial. We don't allow decisions to be made solely based off of a defendant's, self-assessment of his own mental illness and the court's observations. It's that coupled with evaluations from mental health professionals. And that's because, severe psychiatric defects are not always apparent to laymen. I mean, the trial court even admitted his own limitations. He said, I can quote you, he said, I have a JD degree, I don't have an MD degree, so somebody else, I guess, smarter than me is going to have to make that decision. And he's making a reference to whether or not he has a mental health issue. I think if you're going to say that as a trial court, then you have the resources to order an evaluation and have somebody, I guess, smarter than him in that field give him advice so that he can make a wise decision. I think the sufficient inquiry in this case would have, at least at a minimum, the trial court should have educated itself on what bipolar disorder is. And that's why I included in the briefs information from the federal regulations, which show that this is a disorder that's almost like presumed to be impairing, that it substantially limits brain function. There's nothing in the record to say that the judge was familiar with bipolar disorder, knew what the symptoms were. So I don't know how the trial court can base it on his observations if he doesn't even know what the symptoms he's looking for are. And that's why I think an evaluation is extremely important in this case for that court to be able to take a realistic account of his mental capabilities. And I think the Edwards court made some really important observations about mental illness, saying that it's not a unitary concept. It interferes with individuals functioning at different times and in different ways. So even if he may understand some rights or the basic trial structure, it doesn't mean that he understands all of the decisions that go into self-representation.
How impaired would a person need to be in order to not be able to, in order for a trial judge to say, I'm not going to allow you to exercise your constitutional right to represent yourself?
What I think is instructive with these facts is that there was a case from the 4th District, Visage, which I cited to in the brief, which had very similar facts to this case. You have a defendant who has past hospitalizations, who has bipolar disorder, and who's presently taking medications, and that court felt the need to not allow self-representation, and that was affirmed on appeal. So I think given these facts, the court would have been within its rights not to, because of the severe mental illness and how it can affect your cognitive functioning. I don't think that it turns on whether or not the person exhibits bizarre behavior or erratic pleadings, but it really turns on what is their thought process in making decisions. And if you have a defendant, in Edwards, the Supreme Court said some symptoms of mental illness can affect the ability to carry out the task, and one of those was disorganized thinking. So you have a defendant like Mr. Woodbury who has bipolar disorder, which can directly affect his cognitive functioning. And an illustrative of that is Dr. Sesta's mental state examination, which showed that he had abnormal thought processes, which included abnormalities in structure and productivity, which would equal disorganized thinking, which could really affect his ability to make the decisions he needed to make throughout this trial. And also, if you look at the symptoms of bipolar disorder and his actions within the context of his mental illness, there could have been several decisions that he made that were not his own free and reasoned choice as an individual, but more choices that he made that were directly related to his mental illness. And that's why I also included a relatively detailed section in the brief on the symptoms of bipolar disorder. So including like in manic states, making reckless decisions, taking unusual risks, having this abnormal affect, which you can see in some of his behavior. You have a defendant who's demanding speedy trial before any discovery on a capital offense, probably about 2 weeks after the state files a notice of intent to seek the death penalty. He engages in absolutely no discovery. And when asked about the guilt phase during the arraignment, he says, I quote, "It's not even that serious to me. It's like a clown." So, I mean, that's not a proper affect. It's not someone who understands the serious nature of this case. And you have him basically telling a juror during jury selection his reason for self-representation. The court never inquired as to his actual reason. And what he tells the juror is that it's so simple, like a child could do this. I never should have been charged with this crap. So I don't think he's understanding the complexity of handling a death penalty case. And that could be directly related to symptoms from his disorder. It also includes an exaggerated sense of well-being and self-confidence. You have a defendant who thinks, lightning is going to strike before he's going to get the death penalty. He may think that he's better than any lawyer that could ever be provided, that he has to be in control. And if that is a delusion of grandeur associated with his mental illness, then that calls into question the whole voluntary nature of his waiver of counsel. And I think that the only way to ensure that he is in fact making these choices of his own free and informed will is to have an evaluation and fully look at the nature and extent of his mental illness prior to granting him self-representation. And that would be following the rule. Determine whether it's severe mental illness involves a thorough inquiry into the nature and extent, maybe a review of his medical records, a review of his latest psychiatric evaluation, or looking through those records of the doctor notes to see if there's been any recent psychosis or mood swings or abnormal thought processes. And once you have that information, then you can make an informed decision. Then if you know whether or not these decisions he's making are in fact his own or ones rooted in mental illness. I mean, you have a defendant who goes through several days of a guilt phase trial only to take the witness stand and tell the jury, I'm guilty, I want to, enter a plea, and then look at the judge and say, what you got, in front of the jury. I mean, that also doesn't show that he understands the proceedings and that he understands the significance of it. And if you
counsel,
look,
doesn't the record suggest that he's already subject to 3 life sentences at the time, and doesn't the record suggest that he essentially made a strategic decision to try to persuade the jury that, because of the alleged sexual assault or whatever you would call it that he had been subjected to before the killing, that essentially would be sufficient excuse to justify not imposing the death penalty in this case? I mean, given the facts of the case, it doesn't seem like it's irrational to focus more on the penalty phase than on the guilt phase, in light of the obvious, record here.
well, I think if you look at what he said to the court before the start of the guilt phase, that he was doing this to set up an appellate record, and then he makes a decision to all of a sudden, I'm going to plead guilty. I mean, I don't know if he's making that choice because, mental illness, it fluctuates. Like, he could have periods of lucidity, and then he could have other periods when the effects of his mental illness affect him more. So I don't know if this was, if you take a case like Covington versus State, where you have a client who's doing a death penalty case right before opening statements, he decides to plead guilty. And the trial court in that case decided to appoint 2 competency experts, have those evaluations done before entering into the plea. And that's even, I don't think as egregious as the facts in this case, because he actually told the jury in front of them that he's guilty, that it's beyond vengeance, it's beyond self-defense. I mean, if his point was to try and get them to, not to give him the death penalty, that doesn't seem rational for him to say, and then to be so flippant in his behavior about saying what you got, judge. So I would disagree with that as saying that that's a rational choice. I think it actually calls into question that decision and whether or not his mental illness is affecting him. And if you look at the time frame in all of this, it's all like a couple of months. Probably a month later, you have the doctor saying that he might be in the manic state of bipolar disorder. So I think I don't know what more you would need from a mental health professional to call into question his competency. You have a doctor who was just tasked with doing a comprehensive evaluation, and at the same time, the doctor feels the need to tell the court, be instructed for the court to consider his decompensated mental state within the context of his trial proceedings. So I don't know. I mean, that to me is a reasonable doubt as to his competency that should stop the proceedings and have him evaluated for competency prior to keeping on going with the case. Instead, he proceeds to the penalty phase where it doesn't put on much of any mitigation. In fact, he made several comments during the opening statement and closing, pretty much telling the jury he didn't even care if they gave him the death penalty. If that's something you want to do, go ahead and do it. So, I mean, that doesn't appear to be rational. If his decision was he wanted to fight the death penalty, I don't know why he would invite the jury to give it to him. I mean, the purpose of like a Ferretta inquiry is to make sure that this defendant is making this decision with his eyes open. And I mean, I don't know how you can do that if your vision is clouded by mental illness. I think the courts need to ensure that they are making this choice, and that's, ensuring the reliability and the fairness of the proceedings. And if you look at this case, to me, it's like, I don't know how a defendant can go from the start to finish of a trial, from being indicted to being sentenced to death, and at no point anyone questions his competency when he suffers from such a severe mental illness. And I think that also applies to point 2, because you have, I think I understand that mental illness and medication in and of itself doesn't equal actual incompetency, but it does provide a suggestion because we know we have a better understanding of mental illness these days. So we understand that medication does have, effects on cognition. I mean, if you look at the state during jury selection, they caused a potential juror because he was on medication. So there are concerns there. And you also have a long history, decades-long history of a mental illness. If you look at the defendant, for example, in Edwards, who was denied self-representation, he had schizophrenia, which just like bipolar disorder is a neurobiological major mental illness. He had previous hospitalizations. He had been evaluated by several mental health professionals throughout a period of 5 years. And that was found to be severe mental illness. And you have Mr. Woodbury, who's had bipolar disorder since the age of 18. At the time of trial, he's 42 years old. He's had as extensive, more of an extensive history of severe mental illness than that of the defendant in Edwards. So, but in all of these cases, even cases where there's just a suggestion of a mental illness like Barnes or Laura Lasada, the court still had an evaluation done. So I think for there to have been a thorough inquiry into his mental capacity for both the ability to waive the right and also for his ability to represent himself, the court should have had an evaluation done and truly assess the nature and extent of his mental illness. And I'd like to reserve the rest of my time for rebuttal, if that's okay.
All right, thank you. Counsel?
Good morning, Your Honors. May it please the court. Rhonda Geiger on behalf of the state of Florida. I'd like to talk about this. I'm going to flip the issues just slightly because I think they're building blocks. I think the first step that the court has to consider is whether or not the defendant was competent and whether or not the judge took the appropriate steps to determine whether or not he was competent. Bearing in mind, of course, that mental illness does not equal incompetency, and there's case after case after case that supports this. You have to look at what the judge did, and the judge did everything that he should have done. He talked to the defendant. He had an ongoing dialogue with him from start to finish, from the very first day that he was before the judge till the very last day. And in order for a judge to have concerns about somebody's competency, he has to be worried, number one, that he doesn't understand the charges against him, and number two, that he can't assist meaningfully in his own defense. So admittedly, the defendant had bipolar. There's no reason to dispute that, but that's not the standard. And counsel keeps saying things along the lines of he has a mental health issue, he could have had defects, it could have had an effect on his cognition. But all the judge had before him was Mr. Woodbury being very lucid, very articulate, very methodical. If you look at his performance from start to finish, and don't just pick out bits and pieces, he filed pleadings with the court. He served those pleadings appropriately. He made objections. He had a strategy, as the court has pointed out. He very much focused on the guilt phase of this trial. And I know that on the penalty phase of the trial. And I know at this point we're looking in hindsight, but to a certain extent we have to do that because the judge has to have been presented with some bona fide doubt, some reasonable, competent evidence of his incompetency before he could even go there. And there simply wasn't any of that. So once that competency is determined, then you have to move on to whether or not he was capable of waiving his right to an attorney, which is a slightly higher standard. And again, it's not just whether or not Mr. Woodbury had a severe mental illness, which is where counsel keeps stopping. It's whether or not that severe mental illness impacted his ability to conduct the trial by himself. So having people with schizophrenia can go to trial, people with bipolar can go to trial, people with depression can go to trial, as long as that mental illness doesn't impact their ability to conduct the trial proceedings by themselves. So again, we have to look at what the judge had in front of him. Minimum of 12 separate Feretta hearings. So that means that Mr. Woodbury was in front of the judge on a minimum of 12 separate days. Those are the days of trial. So 12 separate days of court proceedings, this judge got to observe this defendant. And at no point during that did Mr. Woodbury ever waver or show any signs that he was incapable of conducting the trial proceeding on his own. Bearing in mind, that standard's tough. The courts lean toward competency. They lean toward honoring that Sixth Amendment right to represent yourself. And in fact, the trial court was very thoughtful about that. He repeatedly said, this is a fundamental right, and I want to be very careful before I take this right away. So he engaged in that Ferretta dialogue at least 12 times. But what's more is he had quite an open exchange with Mr. Woodbury throughout the course of this proceeding. They had discussions about the side effects. And, you know, to that point, I would agree with Justice Nunes. What else could this trial judge have done without infringing upon Mr. Woodbury's right?
Counsel, can I just, given the standard of review, I guess one way to ask the question is, given the fact that the judge in this case found it appropriate and correct to conduct 12 Ferretta inquiries, one way to ask the question is, could any reasonable judge have found it necessary to conduct 12 Ferretta inquiries and not to have ordered a competency evaluation?
Well, I don't think at this point we should penalize him for acting cautiously. The case law does in fact say that competency can evolve, especially over the course of a trial. So competency to waive counsel and plead guilty is going to be different than the competency to waive counsel and proceed to trial. So I think it was in fact very cautious and prudent of the judge to continue to engage in those. Knowing Mr. Woodbury had bipolar, it makes sense that as each day of the trial continued, the judge wanted to make sure that his mental health remained the same and that he remained cogent and lucid in front of him. So I don't think that because he engaged in those Ferretta inquiries, it means that he was worried that Mr. Woodbury was decompensating. I think what it means is that he recognized that a trial is an ongoing event, and Mr. Woodbury, he needs to ensure Mr. Woodbury's competence and capability on each and every day of that trial.
Right.
Sorry.
And were you going to say something else, Justice Carrillo?
I was just going to say, fair enough. I guess the answer to my question then is yes. The state's position is that a reasonable judge in a case like this could have decoupled the two things, conducted the Ferretta inquiries, and not have concluded that a competency eval was required. I just want to make sure that is your position.
And that is exactly our position. Not only was it not required, and I think you're absolutely right in pointing out, of course, that abuse of discretion is the standard. So there's no reasonable person could have taken the view adopted by the trial court. And frankly, the only evidence the trial court had that Mr. Woodbury had a mental illness was that Mr. Woodbury disclosed it to the trial court. If you back this up and say Mr. Woodbury just decided not to be honest with the trial court, would we even be standing here talking about his mental illness that would have only basically manifested itself once he had his interview with Dr. Sesta? The way Mr. Woodbury conducted himself in trial, I mean, frankly, was better than a lot of defense attorneys that I've seen. He behaved far more rationally than many, many trial transcripts that I've read.
And counsel, is it fair to say, based on the record, that the trial court wasn't conducting repeated inquiries because he was seeing things that were making him concerned, which obviously that would be a different situation if you saw 12 red flags and you kept doing the same thing. I mean, in this case, he was repeatedly doing the same thing in recognition of the gravity of a death penalty case and, you know, the significance of the interests at stake. I mean, is that fair?
I think that that's fair to say. The judge definitely understood that while death is different, I think we can all acknowledge that doesn't give him the ability, simply because it's a death case, to infringe upon somebody's Sixth Amendment right to self-representation. And looking back and remembering, of course, that we do have to give overwhelming deference to that trial court, when you look at how the judge conducted Ferretta and the fact that he made that finding every time afterward and made a very clear record, at no point did he say, well, Mr. Woodbury, I started to have some concerns yesterday, but today everything seems okay. I would like to talk briefly about what the judge would have had to have with respect to questioning Mr. Woodbury's competence to stand trial. And according to the rule and case law, he would have to have a reasonable ground. And bipolar and medication isn't a reasonable ground in and of itself. There has to be some behavior that would lead him to believe that Mr. Woodbury didn't understand the charges and was incapable of conducting his defense. And competency that's a really modest aim when you think about it. And there's nothing that Mr. Woodbury did from start to finish. And looking at the transcripts, looking at the things Mr. Woodbury did, he very definitely understood the charges. And while counsel might think it's strange that he thought the guilt phase was a slam dunk layup, his representation would most definitely pass the Strickland standard. He focused on the penalty phase. He repeatedly, he asked the judge for mercy, he asked the jury for mercy. He knew that he had killed his cellmate. He knew he had killed Mr. Haynes, and he knew the evidence of that was overwhelming. But what he wanted to do was try to save his life. And that is an accepted standard. That is an accepted standard when you go forward on a death penalty case. There is nothing in the record that gave the judge a bona fide doubt as to Mr. Woodbury's competence. And I think granting him the overwhelming deference that he deserves with respect to that, and with respect to the record that he made 12 separate times, finding Mr. Woodbury competent and finding him capable of waiving his right, that when we give him that deference, there's no other decision we can come to other than that Mr. Woodbury was competent. Which then leads us into whether or not he was capable of waiving his right to counsel, which, as I said, is an elevated standard. But the elevation in that standard comes not with the serious mental illness. It comes with whether or not the defendant was capable of conducting the trial. And again, having the benefit of hindsight, he was capable. He did a pretty good job. He didn't prevail, but that's not really, again, the standard that the court has to look at. It's basically, can he behave in court? And he did. I mean, there are times that he asked questions more articulately than lawyers do. He went into this with a very, very clear plan. He had a defense set up where he was going to try to minimize his behavior. If you look at how upset Mr. Woodbury was that his confession had been recorded, you can see that part of his plan when he went in and wanted to go to trial right away, he demanded a speedy trial rights. He didn't want that violated either. His plan was to essentially admit that this had occurred and then explain to the jury why it had happened. And there's a point in Mr. Woodbury's testimony, in his discussions with the judge, where he makes a comment that he doesn't want any mental health evidence, which I know is a slightly different issue, but it goes toward his ability to conduct himself in trial, where he makes the comment that I don't want any mental health evidence brought in. This is Okeechobee and the demographics are what they are. So he knows he's presenting to a very discrete section of the county and the population. And he wants to put forward this evidence that the person he killed was not only a child molester, but a potential rapist. And he's going to appeal to these people. And at one point he says, what would any normal person in America do? Reach over into the night dresser and blow the guy's head off if somebody tried to rape you in the night. So it was very clear that Mr. Woodbury didn't want this Okeechobee jury to consider mental health issues. He wanted them to hear that it was reasonable for him to kill a child molester and somebody who had attempted to rape him. So looking at that and his trial strategy, it's not really questioned. And again, we do now have the benefit of hindsight, because we can watch how he behaved himself from start to finish of the trial. You can't question that the court even came close to meeting the standard of the severe mental illness, which we don't agree that bipolar is a severe mental illness in this context, especially medicated. But even if it is, that it rose to the necessary level, which is that the defendant was incapable of conducting the trial proceedings on his own. I'd like to briefly move to the medication component. Florida has a court rule, and the case law, again, is very clear that a person who is medicated that's what makes them competent. So the fact that he's medicated is something that this court and the trial court should be relieved about. That Mr. Woodbury himself said, yes, I've been taking the Tegretol. It does have some side effects. I'm not experiencing any of those. And in fact, I'm feeling pretty good, was his exact quote. And he handed the bottle forward to the judge at some point. The judge put all of those side effects on the record. And reading the record from start to finish, if that's a manic phase, then that's an extremely different idea of mania than I think what most people consider. And the fact that Dr. Sesta in his report said that the defendant was manic at the time of trial, the state believes is very suspect. There's no way that Dr. Sesta was present at the trial because he wasn't appointed. There's no way that Dr. Sesta reviewed any of the transcripts because they weren't prepared yet. So looking at that, all we have to judge what Dr. Sesta based his opinion on is what Mr. Woodbury told him. And we have to remember that this is Mr. Woodbury who specifically waived statutory mental health medication so he wouldn't have to submit to an exam with a state-appointed mental health professional. He was very clear he did not want to do that. So the judge, in his wisdom, told Mr. Woodbury, tell this doctor everything that you can for mitigation. Dr. Sesta was brought on board for mitigation and mitigation alone. And he told Mr. Woodbury that. So we put Mr. Woodbury in the position, and I'm not saying it was a bad idea, but that post-conviction, he could present any self-serving evidence that he wanted to Dr. Sesta with no ability for the state to verify that. So I think that while we look at Dr. Sesta's report, the court can give it a little bit of skepticism based on where that information came from, especially if you consult the record and see that Mr. Woodbury was very clever throughout the course of this trial. I guess a couple of points I'd like to address is number one, Woodbury did engage in the discovery process. And I think if you remember, he was, as I mentioned, he was upset that this confession had been recorded. And so he knew he was guilty. He knew that. He didn't need any, in fact, he said, I know what's in the video, I was there. But he did ask that certain portions of it be deleted out. He asked that the court edit out where he admitted to killing the 3 people in New Hampshire, the reason he was in Florida to begin with. So he actually did engage in the discovery process. And again, going back to Dr. Sesta's report and the fact that counsel has brought up issues with the Tegretol, I point out that in Dr. Sesta's report, while he does mention that he thinks that Mr. Woodbury was under-medicated, he didn't bother with the blood test. He didn't actually check his plasma levels. He just makes that assertion that he's under-medicated. But if you go through Mr. Woodbury's medical records, which are actually referenced in Dr. Sesta's report, this is the exact same dosage, the 200 milligrams a day, that Mr. Woodbury was receiving back in 2011. So receiving that same dosage that he had received previously, it seems more like it's an appropriate dosage. Looking at Mr. Woodbury's behavior in court, it seems like it was an appropriate dosage. Looking at the fact that Mr. Woodbury said, I'm feeling pretty good right now, it looks like it was an appropriate dosage. And so to have Dr. Sesta after the fact throw all of Mr. Woodbury's behavior sort of into question, it seems a little disingenuous. And so once we declare that Mr. Woodbury is competent, once we declare that he is capable of waiving his right to counsel, which he is, the next step is, could he plead guilty? And the standard to plead guilt is the same as the standard of competence. So if he was competent to stand trial, he was competent to plead guilt. And all of those are abuse of discretion. So again, no reasonable person. That's a really, really tough standard for Mr. Woodbury to overcome. And again, remembering, of course, that we have to give overwhelming deference to the trial court here. The trial court, who again engaged in this thoughtful discussion with Mr. Woodbury 12 separate times with respect to his waiver of counsel. And not only that, he engaged in this discussion, he engaged in other discussions with him about how are you feeling, how are things going. And I think it's also probably important for this court to know that standby counsel was present through the entire time, including through the penalty phase, but especially during the plea of guilt where Mr. Woodbury got to tell his side of the story, pled guilty abruptly so he couldn't be cross-examined, and then entered into a plea of guilt. So Mr. Woodbury, through the course of this trial, talked to his defense attorney 20 separate times. That shows up on the record. So he met with standby counsel during the trial 20 separate times. Standby counsel was also present at the health evaluation, and standby counsel visited Mr. Woodbury in jail. So this was a very robust relationship between these two people. And I think moving back to competency, there is a standard, there is case law that suggests that standby counsel could come forward and say something. But considering that standby counsel was very upset that the court waived his privilege and asked him to disclose some of Mr. Woodbury's statements, I think this court can conclude that they had a pretty good attorney-client relationship, and especially since both of them believed that information would be privileged. And there was that dismay in Mr. Manship when the court waived that privilege and had him talk about the mental health mitigation. So there just isn't any evidence. There's none in the record. There's none in Mr. Woodbury's statements. The court didn't have any concerns. The prosecutor didn't have any concerns. Standby counsel doesn't appear to have had any concerns, and Mr. Woodbury didn't have any concerns. And so giving this overwhelming deference that we must to the trial judge, the state is hard-pressed to see what else he could have done to ensure that Mr. Woodbury's rights were not violated by allowing him to go forward pro se and being the captain of his own ship with respect to his trial and his defense. Does the court have any questions on any other issues or those? No? Thank you. Then the state would ask that this court affirm the judgment and sentence of the court below.
Thank you, counsel. We now turn to rebuttal argument. Counsel?
I also want to point out the fact that the rule does require that the court to make a determination on the record whether or not he had severe mental illness, and this court did not do so. It doesn't appear that the court really truly looked into the nature and extent of his mental illness, because he did not observe anything that caused him to have a concern. Also, I don't think we can really take into consideration standby counsel in the circumstances of this case, given the fact that they were ordered specifically by the trial court not to do anything. And all the decisions were left up to the defendant. So as the question is asked as to his competency or his representation, I don't believe standby counsel would have felt they had the ability to even raise those concerns. Also, standby counsel doesn't hold the same ethical duties as defense counsel. And as this court has said, there's no such thing as ineffective assistance of standby counsel, which I would surely raise in a case like this, where you have an evaluation that has instructions to a trial court to consider a decompensated mental state, and you don't bring that to the court's attention. Also, I know that counsel had mentioned that he engaged in the discovery process. Actually, some of his discovery was handed to him on a zip drive and video format, and he wasn't able to even actually look at that. He was tasked with deciding whether or not he wanted to have any redactions to the video, and instead of doing that, he wrote a letter to the prosecutor basically saying it's not his job to police the evidence. And then he wrote another letter telling the prosecutor to step his game up, and then also felt the need to say, I am under some sort of compulsion to tell you, nice suit, dang, I will be keeping a close eye on your sartorial. This doesn't reflect an individual who's taking the process seriously and actually rationally coming up with a defense.
Counsel, I'm sorry to interrupt you there. I just want to follow up on what you said about by counsel. You're not suggesting that there's anything that would have prohibited or prevented standby counsel if they had any reason to believe, based on what they were observing or based on their interactions with the defendant, to alert the court to the possibility that they were not mentally competent to be doing what they were doing. I mean, are you suggesting that they couldn't have done that if they had reason to believe that?
I mean, I would hope that they would have the ability to do so, but the order that was issued by the trial court very specifically tells them that they are not allowed to do anything. So in this case, and that's why I say only in this case, given the circumstances of the way the trial court issued its order, it could potentially be the reason why standby counsel didn't say anything. But normally, I don't think that they would feel like they wouldn't have the ability to do so. Also, I also think it's hard to require a defendant to prove his actual incompetency when we have these procedures, and the courts are supposed to follow them so that we have an adequate record to make these determinations. And because there was no evaluations into his mental state, I can't tell you what his mental state was at the time of trial or the time he took his plea. You know, we're just assuming based on observations alone that there was nothing wrong with his cognitive functioning. And I think that had the court followed the procedure and issued an evaluation and truly determined whether or not his severe mental illness affected his ability to represent himself or even his ability to proceed to trial, that there would have been possibly a different outcome. But it's uncertain. And when these procedural rules aren't followed, which leaves his mental state uncertain, I think that's where the analysis ends. That's the full fundamental error. And I think that while the task may be difficult, the trial court has to adequately follow these rules of procedure, because that you have to ensure the fundamental fairness in the system. You have to deal with the fact that courts are supposed to be fair and equitable instruments of justice, and that can't be done in the case where there's an uncertainty as to his mental state. So therefore, I would say that allowing this defendant with a severe mental illness to represent himself in the capital case without any inquiry into his mental capacity to represent himself violated the rule, also denied him due process, and I believe requires reversal for a new trial. Unless there's any questions the court has. No?
All right. Thank you, counsel. We thank both of you for your arguments, and the court will now prepare to take up the final case on today's docket.